Hi, everyone. Good afternoon. Welcome to my webinar. We are just under the hour. We're starting at 3 p.m. Eastern today, so I'll give everyone a moment to get started. So welcome. Good afternoon. I know we're just heading into the long weekend. If you're in Canada, it's Labor Day weekend here. So we will thank you again for joining me so late on a summer Friday afternoon. So I will let everybody slowly join and we'll get started in a couple of minutes. For those who are watching this recording after the live session, welcome. My name is Jade Calver. I own and operate Calver Immigration Consulting Inc. We are a full-service immigration firm located in beautiful Ontario, Canada. So I am hosting this webinar because we had I host a Facebook group for immigration consultants and lawyers. For those of you who are not already in the group, please, you can private message me either on LinkedIn or you can email me. My email will be at the end of this session. If you'd like to join my private group for immigration professionals, please do so. And so again, today's webinar is really just as a result of people, both my clients, my employers, my clients who are foreign workers, either here or outside of Canada, as well as my fellow immigration professionals that were asking a lot of questions about the recent policy changes that happened this week in immigration. So it's been a busy week for immigration. So today what I'll do, I will run through the changes and I'll talk about implications for your clients if you're an immigration professional or if you are an actual employer or a foreign worker who's going to be navigating these changes. I will also go through what that means for you. I don't have the answers to everything yet because the government, in true typical fashion, has announced the changes and then they haven't actually sorted out how it's going to be, how the changes will be implemented. So I'll go through the changes that have been announced and then I will open it up for a live Q&A and I'll stay here for as long as you need about these changes so you can ask your questions. Remember, this is a public forum, so anything too case specific, you might want to save it for a one-on-one conversation with me. But again, general questions about the changes to the LMIA program. We'll also talk about the changes to the visitor to worker policy. And then there was a less popular but still important change to work permits for those who have applied for PNP programs. So I'll cover that briefly at the end as well. So without further ado, we are 3:02 p.m. So I'll hop right into things. So again, as I said, my name is Jade Calver. I'm a regulated Canadian immigration consultant, so an RCIC for short. I own and operate a boutique immigration firm, Calver Immigration Consulting. We are a full-service immigration firm located in Ontario, Canada, but we help clients across Canada and across the world move both their businesses and their workers to Canada. So I will premise this by saying I've been working in immigration for a long time. I did a dry run of this presentation with my staff this morning, and it's been since 2008. So it's been quite a long time that I've been working in the Canadian immigration field. And what that means, and I want to premise this by saying, and why I bring this up is that, this is not my first pre-election season that I've been through. And what I mean by that is that the changes that the government is announcing, the pendulum swings back and forth when it comes to immigration changes. So I see a lot of the changes today. They are a result of really just the pendulum swinging back to, pre-COVID times. So those of you who are a little bit newer to the immigration profession, maybe you've only started in the last couple or 2 or 3 years, these are actually a reversal to the conditions that we saw of the labor market pre-pandemic. And a lot of the changes that they've reversed were only a response to a COVID market. And so I think that we can think a lot of these, some of the changes may seem unwarranted or unfair, but I think that a lot of these changes that came into effect, so then both the public policy for workers to apply from visitor to worker, as well as the LMIA conditions, I think a lot of those were a response to an unprecedented COVID market. And now what we're seeing is a return to a normal market where, again, with the temporary foreign worker program, the whole point is, again, as I say, I have an LMIA training, which you can also take. It's to protect the Canadian labor market. So again, the first change that we saw this week is that the government announced 3 major changes. They're mostly to the low-wage LMIA programs. So the first one is that there's going to be a refusal to process for low-wage LMIAs in economic regions that have unemployment rates of 6% or higher. So the government has said, and again, this used to exist previously, pre-COVID times, that if you are submitting a low-wage application, let's say you're trying to hire for a Tim Hortons for someone to come work there, and you are in a region that has 6% or higher of an unemployment rate, you are not going to get your application processed. So they're saying, don't even bother, we'll refuse to process the application. Next is that overall, Canadian businesses will be reduced to a cap of 10% or lower for how many foreign workers they can have at their job site. So what this means is that out of a total workforce, only 10% of your total workforce can be made up of employees who are there as a result of a low-wage LMIA. So, for example, if you have 100 people working at your workforce, we'll make it easy for my math, and then that means that only 10 of those workers would be able to obtain a work permit based on a low-wage LMIA. So what that means is that if you try to file for an LMIA after September of this year, and your cap calculation makes it so that you would go over 10% of low-wage LMIA holders total, they will again refuse your application. And then lastly, another big change, which I think is not being talked about enough, is that the duration of work permits for low-wage work permit applications will actually be reduced from, right now you'll get 2 years if you submit a low-wage LMIA-based work permit. Now they're going to reduce it to 1 year. And so what this means is that if you are applying for a work permit for somebody, whether they're inside or outside of Canada, which we'll get to in a minute, they're only going to get 1 calendar year on that work permit. So if you are an employer who continually files for and relies on these low-wage workers, keep in mind that when those workers come, you're now going to have to actually start the LMIA, I would say almost immediately. And this is what we used to do in the past when it was the case that you would only get 1 year. We would start the LMIA process, because LMIAs take so long to process, 2 to 3 months after that worker had arrived in Canada. Because if you want your workers to keep working, you're going to have to continuously file for LMIAs to keep them working in those low-wage positions. Excuse me. Next, so what employers should know about these changes to the LMIA program. So a few things we don't actually know. There are economic, which I'll get to in my next slide. We're not quite sure which regions have the 6% or higher unemployment rate. Yes, there's some information online, but those economic regions don't actually match the economic regions that ESDC uses for its LMIA applications at the moment. So I suspect that in the coming month, I think there's a date, I think it's September 26, 2024, the government will release the actual data set that we're to use to determine the unemployment rates. So right now, I would say that most of my employers who are wanting to file LMIA, low-wage LMIA applications, we're waiting to see what that data set looks like so that we know if they're going to be subject to the refusal to process or not. And then next is that your current LMIA work permit holders will not be affected. So what this means is that if you have low-wage workers at your workplace, so if you are going to be subject to the lower cap of 10%, what this means is that you, if you're going to be subject to that 10%, if you are at 20% or some of you are at 30% because of your industry, you're not going to have to lay off or terminate those workers. So current LMIA-based permit holders who came under the low-wage program, they're not going to be affected at your current work location. It just means that when you put together a new LMIA application, you will be subject to that 10% cap, so you do have to be careful. I also wanted to bring up that the government has announced that there will be some exceptions to these rules for both seasonal and non-seasonal jobs in specific industries. So they've named primary agriculture, food processing, fish processing, as well as construction and healthcare. So these are industries that see major labor shortages on an ongoing basis. So our understanding is that the cap restraints won't be as strict for these industries, and that we're assuming that the refusal to process for unemployment region, for the unemployment rate where it's 6% or higher in that region, it won't apply to these industries. But again, we do have to wait until the end of September to figure out if that applies to that, to you as an employer or not. And so that brings me to the last part regarding this topic, is what we don't know. So again, as I mentioned earlier, those economic regions, so right now they're saying if you have that economic region where you have 6% unemployment or higher in that region, we won't process a low-wage LMIA. As I said, the economic regions that they've published and the data sets that I'm seeing, they don't actually match what we see for the economic regions that determine the wages for LMIAs. So previously, when a similar restriction was in place for LMIA processing, we actually had a data set that matched the unemployment or the economic regions that we use for LMIAs. So I think that they'll probably come out with a link to a data set that's more specific for these applications. We also don't know. I think a big question for myself, my colleagues, employers out there is those of us who submitted an LMIA application prior to the changes that were announced this week. Do these changes apply to ongoing applications? Generally speaking, ESDC is a little bit nicer than IRCC when it comes to these changes. And generally speaking, they will grandfather us in. So meaning that, I have low-wage LMIA applications that are that I submitted prior to the change that will technically be subject to the refusal to process because they definitely have an unemployment rate of 6% or higher in that region. But the question remains, will they honor the fact that we submitted that prior to the changes that were announced this week? Or will they say, no, this applies to everybody who doesn't have a decision yet? Similarly, length of work permits, we're unsure, will it affect only low-wage stream applications? But keep in mind, we can also submit low-wage LMIA applications that are under the PR stream. So we don't know also if the length of work permits will be 1 year for those PR applications. I would hope not, but anything is possible. I'll also note that the government has hinted at changes to the high wage stream. We may see certain restrictions on occupations or location under that stream. They also have hinted at other changes to the temporary foreign worker program. So really what remains to come, it remains to be seen. But we do have to, again, for this low wage restriction, we have to wait until the end of September when they're going to release the information. For now, my employers who are wanting to hire to submit low wage applications, I'm saying unless they can go through the PR stream, I'm saying hold off until we know if you're subject to the refusal to process. And then everything else when it comes to the PR stream and the high wage stream, As of now, it's business as usual. So again, and then those who have pending applications, who I think will probably be those that are the most affected, it remains to be seen end of September if we'll be subject to the changes or not. Great, so that's the temporary foreign worker program changes. Next, I wanted to talk about the second major policy announcement that happened this week, and that was the end of the visitor to work permit policy. So this is a COVID era policy, and it allowed visitors to apply, visitors who had valid status from within Canada, who had a job offer either backed by an LMIA or that was LMIA exempt. So think about your Francophone mobility work permits, your charitable work permits. We could even do it with spousal. We did it successfully with spousal open work permits. So you are actually allowed to convert your status from a visitor to a worker. And that was due to end in 2025. However, abruptly, the Immigration Department this week announced this program is over. If you're a visitor, you can no longer apply to change your status in Canada. So big upset, especially for those of us who got used to this program and who were using it as a tool to help our clients convert their visitor status to worker status. So what this means now is that if your temporary foreign worker is in Canada, you have a few options, but you cannot convert that visitor status to worker status. So that means that maintained status that used to result as a result of these applications. So maintained status, for those of you who aren't familiar, if we submitted an application before a visitor permit expired, usually within 6 months, that meant that that visitor could stay in Canada and then be granted the work permit without ever leaving or having to extend their visitor status. So this is no longer applicable. So what are the solutions going forward? So first and foremost is flag pooling. For those of you who follow me on LinkedIn, I already posted this list, but I thought, and again, everyone's questions on LinkedIn prompted me to host this webinar as well. So one of the solutions could be flag pooling. So if you're applying for a closed work permit with an employer, and if the client is near a port of entry that we think is friendly to flag pooling, we often, and going forward, I think my first course of action, this is if the person's already here in Canada, I will be sending them to flag pool for an application. So this is where, by virtue of the regulations that allow you to go to a contiguous country, so that's the United States. So again, someone said to me on LinkedIn that you had to have a TRV to flag pool. That's not true. The regulations make it so that you can go into the US and come back even if you don't have a valid TRV. And this allows you to, what we call in the industry, flag pool for an application. And so if a person has a job offer from a Canadian employer and they're here as a visitor, we can actually send them to a physical port of entry with the United States. And that is where they will submit an application in person. And it's really the quickest type of application because then it gets issued there in person. The second option is that outland applications for temporary foreign workers in Canada, but you have to maintain your status. So what does this mean? So this, for those of you who aren't in the immigration industry, it might seem like a little bit of jargon. So it means that those of you who are in Canada as a visitor, who are going to use the visitor to worker policy to apply for a work permit, you now would apply using an outside of Canada application. So there's a form, the 1295 work permit application form. So that's where you would submit that application based on your LMIA or your LMIA exempt work permit. So you submit that and that puts your application into processing. And then because you have temporary status in Canada, you have to either extend that status if you want to stay in Canada, or you can leave and then wait for a decision on your work permit. But you have to remember that previously under the policy where there was just one application, often you'll now have two applications for someone who's trying to stay in Canada whilst their work permit application is being processed. Next is an outland application. So this is very simple. If you have an employer who's doing an LMIA or an LMIA exempt application and the person is in Canada or is outside of Canada, you just do an outland application, meaning you apply online and it's processed through the foreign visa office for that country. And then lastly, this is something that I find for whatever reason, consultants and lawyers forget about and don't like to use, but we also have a port of entry application, but this is not flagpoling. Port of entry applications is only for TRV exempt individuals, meaning you don't need a travel visa to Canada. So most of Europe, some South American countries, United States, Australia, Japan, New Zealand. So if you are a citizen of one of these countries and you have an LMIA or an LMIA exempt job offer, you actually can come to the border and submit what's called a port of entry application. So for those who are in Canada, or outside of Canada and are navigating the work permit process, I think that these port of entry applications will become a lot more enticing, especially given the change in the visitor to worker policy. Great. And then just lastly, just to finish off my part of the presentation, so provincial nominee applicants can now get open work permits. So there's a new policy that was also issued this week. So what this means is that applicants for provincial nominee programs, if they have a work permit or had a work permit on May 7th, but that has since expired, and if they have applied, either if they have an expression of interest in for a PNP application, or they have a pending PNP application, but no nomination certificate yet, they can actually, with the help of a province, so they have to get a letter from the province, which is the one kicker. So if they have the letter from the province, they can actually apply for an open work permit, meaning that they don't have to wait for the nomination certificate. However, as one of my colleagues pointed out earlier today, currently only Alberta and Manitoba have these letters available. So, but we do expect the other provinces to follow suit and start to issue these letters. I think it would be really helpful. I think this policy is aimed specifically at postgraduate work permit holders who are running out of status and are trying to get permanent residency. So just something to take a look at if you're applying for a provincial nominee program, especially right now in Alberta or Manitoba, or as the provinces begin to expand this program under their PNP programs. So that is everything from me today. So I will open the floor to questions for a live Q&A for the next 30 minutes, let's say. So please put your questions in the chat. Thank you so much for joining me today. Again, you can always reach out to me directly. I will answer questions, as I said, as a live Q&A. But if you want to get in touch, we are online at Calver Immigration Consulting.ca as well as calverimmigrationservices.com. You can follow me on LinkedIn. I'm also on all the socials, YouTube, Instagram. I'm on TikTok these days. So please follow me. If you're an employer or if you're an RCIC or a lawyer wanting direct assistance, usually LinkedIn or email is the best way to get me. Our socials get a little bit clogged up with messages, so please message me directly there. And thanks again for your time, and we will hop over to questions. Okay, so let's take a look at our Q&A, please and thank you. Once I figure it out, give me 1 second. Stop share. Pin. Okay, so let's go to our Q&A. So Sandeep asks, will this LMIA change impact applications that have already been submitted? So hi, Sandeep. So again, for LMIAs that are approved, I would be very surprised if the department goes after existing LMIAs that have already been approved. It would be very unprecedented of them to do. The only thing is that I think that if you, as I said earlier, if you have an application that was filed, before these changes were announced, I think that we're not certain if they're going to grandfather us in and say, you submitted this application before the refusal to process conditions were announced. And so it remains to be seen if those applications will be affected or not. Okay, a next person says, what are the potential long-term impacts of these changes on the Canadian labor market? Who are you? Maybe you're a reporter, I'm not sure. So I think that overall, these are tightening measures on the Canadian labor market. I mean, there are two schools of thought. I mean, from one perspective, I can see that it's good for the labor market, especially for our youth who are graduating. It's no secret that we're in a little bit of a mini recession in Canada. So for those who are looking for entry-level work, I think that a lot of Canadian employers got really used to being able to fill positions, especially in fast food restaurants, quick service restaurants with foreign workers. I think that this will open up positions to Canadians. However, I think that a lot of skilled workers do come in through the program. I think that we may see skilled workers who we're going to, yes, eventually become permanent residents who won't be able to come on work permits anymore. But again, it's no secret that the number of temporary foreign workers under the program has really ballooned in the last couple of years. And I don't think it's necessarily a good thing, especially because a lot of those foreign workers who are here had no transition plans that were, it was impossible for them to transition to permanent residency. So they weren't necessarily helping the labor market. And again, I think we need to remember that the temporary foreign worker program is supposed to be a last resort. So I think that it will push Canadian employers to train Canadians a little bit more rather than looking for that quick fix, which is sometimes foreign workers. However, as someone who works in immigration and who has been doing this for a long time, I think that we have a lot of positions in Canada that, quite frankly, Canadians aren't going to do. They are remote. I think that they're difficult. They're physically demanding, and I think that they're impossible to fill. So I do think that it'll be interesting to see. I think that we'll see some pushback from the private sector, from employers in certain industries on the government for restricting foreign workers in these types of visas. Okay, so someone says, how will these changes affect employers who rely on the temporary foreign worker program? Right. So I think that, as I said earlier, those who rely on the temporary foreign worker program, it really depends on who and where they are, right? I mean, in some cases, I think that they may have to, I think it could be beneficial. There are two ways to look at it. In some ways, it would be beneficial because they're going to create more jobs, maybe increase wages to try to attract Canadian labor to their positions. But on the other hand, perhaps they are unable to fill the positions, unable to offer higher wages to workers in the positions. And so maybe Canadian businesses will suffer because they just won't have anyone to staff their work. So I think that, again, as I said, two schools of thought. I have my own thoughts on it. I think that Canadian businesses are going to suffer as a result of these temporary foreign worker program changes. I think that the employers that I work for, they really hurt for staff in these positions. And so I think that we're going to see a lot of employers really struggle to staff these occupations. Someone asks, can you help RCIC set up including marketing? I've been following you since COVID. Okay, so this isn't pertaining to the topic, but yes, I would love to connect with you. You can, as I said, DM me on LinkedIn or send me an email. I'm happy to help you with your startup in immigration. Someone asks, how does your virtual consultation work? So yes, we offer virtual consultations. You can book them on our website directly, or if you have questions before your consultation, send us an email. Happy to chat. Oleg says, according to the new instructions on the IRCC website, POE apps for work permit, if a foreigner needs a TRV, they're not allowed. Well, that's nice. IRCC, my response to that, Oleg, is that IRCC is not the law. So the law is the act and the regulations. And so I think that this wouldn't be the first time that IRCC has put something on their website that isn't a correct, in my opinion, interpretation of the regulations. This was especially pertinent during COVID, where IRCC was quickly interpreting government policy and legislation to as it pertained to COVID policies. And I often found mistakes in how they were interpreting the policy. I would also say that IRCC doesn't administer port of entry applications, CBSA does. And so in my opinion, IRCC has no, has no business telling us who can apply with a TRV. I think that they're incorrect in that. Someone says, do I understand correctly, POE apps is not equal to flag polling? Yes, correctly. So POE application and flag polling. So great question, Oleg. So flag polling means that you've gone in from flag polled, meaning you've gone from a contiguous country. And so it's treated like an in Canada application, whereas a port of entry application, what I mean by that is that you have come from overseas, you've flown into Canada, and then you're submitting at the POE. So if you're doing that, if you are from a TRV requiring country, let's say you show up from, I don't know, India, for example, they're going to say no, they're going to say you have no business doing that. Whereas that same person coming from India, flying into Canada, and then they're admitted to the country, they then, if they have the job offer, can then go ahead and flag poll. But you have to be careful with these, because if you do that, and if you do it too early, because remember, we have to be careful about misrepresentation here, because if you fly into the country and you already have the job offer, and let's say you send your client down to the border, and then they are trying to do a flagpole application, and it's only been a week, they're going to say, the border officer, if you get a stickler, might say, actually, I think that you misrepresented when you were entering last week. I don't think that you are coming in as a tourist at all. I think that you've had a job offer the entire time. Therefore, I'm issuing you a removal order. Not only am I issuing you a refusal for your work permit, but I'm issuing you a removal order. So you do have to be very careful about the timing of it as well. We often let clients, if they're coming into flagpole, I let them sit in Canada for a little bit. And then that way they can genuinely apply for the job offer and then apply at the POE. Great. Next person says, to confirm, outland application for applicants who are physically inside Canada does not give maintained status. So for applicants, we need to submit an application. Correct. Yeah, Susanna, that's exactly right. So those who are in Canada, so if I am a visitor and I have let's say I got an LMIA, I'm going to go work at Tim Hortons to be a baker. If I'm a visitor, if I submit I can't submit the 5710 form. I have to submit the outside of Canada application. So that's the 1295 application. And then I have to figure out, what am I doing with my visitor status? Am I going to, because it's only valid for 6 months, I might not get that decision on the work permit. So I can extend my status as a visitor for 6 months, before 6 months, or I can leave, or I can maybe leave and then come back. So you just have to be careful, because you can't let your status as a visitor expire, because then you're out of status and you're going to have bigger problems with IRCC. So you do have to be careful with that. Great. Okay, so can you explain the outland application for temporary foreign worker in Canada, as I'm not clear on it? So I think I just, okay, so this is relating to spousal sponsorship. So it's great actually that you bring that up, Patricia. So we're talking about the visitor to worker policy. So that was for people who are applying as a visitor for a closed work permit, meaning they had a job offer from an employer. So people, I think, are like you, are going to conflate the visitor to work permit capabilities for spousal sponsorship applications. So if you have an inland or an outland spousal sponsorship that's being filed, it does allow you to apply for a work permit from within Canada. And so a couple of things. So there are 2 public policies that keep a person in status. So if you're doing an inland application for spousal sponsorship and you file an application, you automatically are granted status. You can also apply for a work permit if you filed either an inland or an outland application. So those people are not affected by this policy change. If you file a work permit before the person's visitor status expires in Canada and they have a pending spousal sponsorship application, they'll maintain their status in Canada. So that means that they can stay in Canada and keep working. Great. Okay, you guys have lots of questions. This is really great. Abelar says, where would you send the temporary foreign work permits passport for stamping after the application has been approved? Someone asked me that in my group today. I believe it was Ottawa. We did a lot of these prior to, yeah, it's Ottawa, because when you get the approval letter, they'll say, you know, send it to the visa office for the country in which you're currently located. So then you send your, so what happens? So I think that you're conflating two things. So the passport would be stamped, but then you'll still get the approval letter for the work permit like you would if they're outside of Canada. So then there's a second step. They don't just get the work permit sent to them, so they get the passport stamped if they need to, and then they get the border approval letter, and then they have to flagpole or physically fly, leave the country and come back in to get the work permit, the actual physical work permit activated. So there are a couple of steps in addition to sending in the passport. So it's a little bit different than before. When we did the in Canada application, they would just send us the work permit. Now they're going to have to send in their passport, and then they're also going to have to go to the border and get their passport, their work permit issued. So be careful, because you still have to maintain the client's status whilst they're in Canada. So do be careful with that. Abdul says, does OANP send support letter under the home care? I'm assuming this is the home care, oh no, human capital priority stream, or we need to ask OANP. So Abdul, that letter, that policy that I just mentioned, the new one, it's only Manitoba and Alberta that send the letters at the moment. So if you're applying under the OANP, until you get a nomination certificate, you're not going to be able to apply for a work permit. So unfortunately, Ontario hasn't taken the government up on those letters yet. So stay tuned. I'm hoping that they'll follow suit, but right now they don't issue those letters. Great. Snav says, thank you for the session, Jade. You're very welcome. We value your time and effort. Can you please clarify the part you mentioned about flagpoling? The applicant doesn't need a valid TRV. So I've already answered that. So again, it's the contiguous country rule. I'll send that up when I send clients to the border and they're doing this. I include an opinion letter with a printout of the regulation, and I highlight it for the officer, because CBSA officers don't understand this either, and they'll often take the approach that all of you have taken and that IRCC has on their website, that you can't flagpole if you need a TRV, but it's not true. So I'll send some information on that. Great. Change visitor to worker. Does it apply for spousal open work permit or just closed work permit? Example, spouse of a master's degree student who entered Canada as a visitor and wants to change it. I would argue, Auguste, that it has reverted to what it was pre-policy. So I would be doing an outland application to be safe for spousal open work permit, and then also maintaining their status. So same thing that I've just been talking about, I would be doing the outland application for them. Great. Someone says, I currently have a valid visitor visa. Is it possible that while my work permit application is in process, I can be in Canada? Yeah, so visitor visas, so those are called TRVs. That's just what gets you on the plane, everybody. So those of you who aren't RCICs or lawyers, I'm assuming you're not an RCIC. So what happens is that the TRV allows you to board the plane, but then when you're granted entry to Canada, you're given what's called a visitor permit or a visitor record. And so that's your actual status in Canada. So if you have a TRV that's issued for 10 years, that doesn't mean you can come to Canada as a visitor for 10 years. It means that when you enter Canada, you get 6 months, unless the officer tells you otherwise with a document or a stamp, but you get 6 months. So that means that within those 6 months, you need to either extend your stay or leave the country. That's it. Those are the rules. Next person says, for an open work permit under nomination, does the applicant need to submit the PNP application that is attached to the employers, or any PNP applications that would be fine? Also, do we need to wait for the province? Right. So a little bit of confusion about that PNP public policy. So it's the provinces, if you have applied and you don't have the nomination certificate, or if you're in their pool of candidates, provinces will have their own instructions to give you letters that will allow you to apply for the open work permit. So again, right now, it's only Alberta and Manitoba that issue these letters. So it really, if you've applied under those provinces and you're waiting on a decision, and they've given you a letter, then you can apply for the open work permit. But again, it's only those 2 provinces that you're allowed to do it. Okay, next, Pamela says, This is a long one. So for visitors in Canada applying for a work permit outside of Canada, once the application is approved and passport is requested, can the applicant send the passport to Ottawa? Yes. For visa stamping and then go to the nearest border with a letter of introduction? Yes. So I think I answered your question before, Pamela. So yeah, you can do that unless for some reason they're starting to say that you have to send it to New York. But previously how this worked is that we sent them to Ottawa. Great. Someone says, I am an RCIC and I have a client with an approved LMIA. Great. And the worker is in Canada as a visitor. The work permit application has not been submitted. Does the worker have to leave the country, or can an outside Canada application be submitted? Right. So this is a really great question. So they have an approved job offer. So your options are you send them to the port of entry, to flagpole. You're only doing this if they present well, if they're in valid status, if they have good ties to home country, no previous refusals, and you can put together a good border application. If that's not an option, or if you're just too scared to do it, which is fine, I understand. And if you're a representative, don't be afraid to go to the border with your clients. Hop in the car, drive them down to the port of entry. The officer won't talk to you during the first exam, but you can help them through the process. So, if you have someone who's really nervous, but they really need that work permit, you can help them through that process. Okay, next option for your client, Carl, is that you submit a 1295. So that's an outside of Canada application. You explain that they're just in Canada visiting and that you're submitting an application for an LMIA-based work permit. And then you have to figure out what are you doing with their visitor status. Are you going to extend it before the 6 months expires, or are they going to leave? What's the plan there? Or the other option is they go home and they apply from outside of Canada. Great. What is the best option if you are in Canada without status, but you have an approved work permit? Well, okay, so if you are out of status, you need to leave or restore your status to correct it. So this is getting into a this is going down the rabbit hole of people without status. I don't think that we're talking quite about that today, but generally speaking, if you're without status, you can either correct it by leaving, or if it's been 90 days since you had a refusal on your last application, you can restore your status to the previous status. Okay. Dahlia says, we've previously submitted these applications. What are we talking about here? 199. Are you talking about flag pulling, I think, Dahlia? So yeah, so I'll send out the instructions and the regulations, Dahlia, that you can use to help your clients. Okay. Adriana says, with clients that do flag pulling and do not have a US visa and are successful in obtaining the work permit for future applications, do you need to disclose the administrative refusal? Yes, actually, that's a really great question. And honestly, really smart of you to understand that. I think that when we're going to the border, Steve Murrins, who is an immigration lawyer, he has a brilliant podcast that he does weekly approximately. And recently he was just talking about some federal court decisions regarding these misrepresentation for not having declared these. So yes, I always, if someone gets the administrative refusal, so what happens is that when a client goes to the US and they get an administrative refusal, what happens is that then they go back to the Canadian side and they get their work permit processed. So if they, if they're getting that refusal from the US, then we always declare it in future applications. Okay, Rob says, can you still do the visitor to work permit under the French LMIA exempt, or do they need to do the Outland application? Right, great question. So I talked about two things today. So there's the LMIA temporary foreign worker permit changes. So temporary foreign worker program changes. So those were the changes for the refusal to process for low wage LMIAs. And then there's the end of the visitor to worker policy. So that's for all work permits. So that's for your LMIA-based work permits, but also Francophone mobility, charitable workers. We have certain international agreements. All of those work permits that are that are closed work permits, it's an end of the policy for all of them. So if you're applying for Francophone mobility work permits for your visitors, they would have to flagpole or again, do that dual application that we talked about if they're here, or they leave to their home country and apply from their home country. Next, Rena asks, does the new policy cover PGWP that expired and convert to visitor visa? It's a new policy. I'm not sure. Rena, if you expand on your question a little bit more, I can maybe try to help you with it, okay? Great. The client, okay, this is specific. The client's currently in Canada, submitted an outside of Canada work permit application. His current visitor record is valid until May 2025. Does he need to submit a new VR application in case the work permit application is refused? Or his existing VR, which expires? Yeah, so if the work permit's refused, that doesn't mean that it doesn't have any effect on his current status in Canada. So that client would still have status in Canada up until May 2025. Okay, Letitia says, if someone is transitioning from a postgraduate work permit to a work permit under the International Mobility Program. No, so great question, Letitia. So those who have visitor status, those who have a work permit or a study permit, they are not affected by this change because they're going from a work permit to a work permit or a study permit to a work permit. So they are able to do these change of conditions still. It's only for those who have visitor status and then they're applying for a work permit. That's where you can't do that change of conditions from within Canada anymore. So again, if your clients are on a study permit, if you're on a work permit and you're changing to a work permit, you can still do an in-Canada application. And then someone asks about the Iranian public policy. So the Iranian public policy is separate. It's still an ongoing public policy for Iranians. So for those of you who don't know, up until February of 2025, Iranians who are in Canada can apply for an open work permit for a duration. They'll get a 3-year work permit. I will say, I wouldn't be surprised if the government ends that program early. So if those of you who are in Canada, or if you have clients who are in Canada who are Iranian and they're going to apply for these work permits, I think that I would be submitting it right away because I wouldn't be surprised if the government cancels that program, quite frankly. So be careful with that as well. Great, so I'll take one last question if anyone has it, and then if not, I will finish things off for this wonderful Friday afternoon. It's beautiful and sunny here, so I probably need to go outside and go kayaking or something for the Labor Day weekend. Okay, one more question. Here we go. The client submitted closed work permit with an LMIA when they hold PGWP, but the application was declined. The postgraduate work permit is now expired. Can we restore the status to work permit? Yes. Message me, happy to co-counsel. If you're a client, happy to help you with your application. Have a wonderful weekend, everyone. Thanks again for joining. If those of you who are looking for more help, I have LMIA training online. I have a second company which does training for RCICs and lawyers, levosolutions.ca. You can also message me at any time. I'm happy to do one-on-ones with you as a lawyer or a consultant to help you through your trickier files. Thanks again for joining, everyone. For those of you who are watching this after, if you're watching this during the recording, thanks again for joining. And thanks again. Have a wonderful weekend, and we'll see you all soon.